If we're going to cover this wall to wall, then let's be fair about this. There's a probable cause warrant or affidavit for a warrant that is uncross-examined, that has got holes that you could drive a Mack truck through, and I've listened to 20 minutes assuming that this is the guy.
Hello and welcome to True Crime Rocket Science, the most authentic voice in true crime. Well, it's on. Brilliant Bryan will face his toughest test in this high-profile criminal trial. Will he pass? Will this actually be his PhD? So, as you guys are no doubt aware, Kohberger will challenge the evidence against him. But think about it, have we ever seen anything like this? A prime suspect with almost a PhD in criminology about to test that knowledge in a high-profile criminal trial. Basically about to test the criminal justice system, to confront, possibly to challenge the efficacy of the criminal justice system. I mean, isn't there a sense when Kohberger walks into the somber and studious confines of the courtroom in Moscow, Idaho, that it feels like familiar territory to him? It's sort of like a classroom setting. It's not that different from a lecture hall. You have an authority figure at the head of the class. I mean, in court, people silently sitting, observing, taking notes in the class, court, and then a solitary voice speaking, some questions asked and answered, schedules and breaks. It all looks and feels like yet another sort of didactic scenario. So if Kohberger ever wanted to show off his superior intellect, well, now he has his chance. And that appears to be why he's elected to waive his right to a speedy trial. He does want that platform. He does want that theater. He doesn't want to rush it. He wants to luxuriate in it. And we've already seen signs that Bryan is already actively participating in his own defense. We know that he helped draft his public statement. That is according to his original defense attorney. We also know that he waived extradition. Instead of buying a little time to prepare his case, he waived extradition, and that suggests the defendant is either very confident of his innocence or confident of his case, or both. And some people have said, well, it was really just that he was so curious to know what was in that affidavit. But it could also be that he was trying to send a message, that he was trying to say, I'm not afraid to have my day in court. I'm not afraid to plead my case. But do you see the contradiction? We have a sense of Kohberger as withdrawn and neurotic, nervous, anxious, right? So why wouldn't he want to pull a Chris Watts? Why wouldn't he want to plead guilty, avoid the noisy circus of the courtroom, the damaging exposure of a full-blown criminal trial? On his first perp walk, during his first hearing in Pennsylvania, he had to have been painfully aware of the intrusive glare of all those cameras and reporters, lenses and onlookers, folks craning forward, their phones aloft, trained on, locked in on the curious, creepy suspect. So if he is a nervous personality, and isn't that the case we've been trying to make in the last few episodes, if he is something of an introvert, if he is socially awkward, if he is neurotic, why not dodge a trial entirely like Chris Watts did? Or why, at the very least, not elect to have a speedy trial and get it over and done with ASAP? Why drag it out? These are obviously crucial questions, but before we get to that, if you haven't subscribed to the channel, please do. Welcome to the hundreds, thousands of you who have subscribed. I am turning on the captions for those who asked, and also for those who want to join Patreon, I'll put a link in the description. In terms of this video, we are going to look at the defense case. So it's not as though I'm cheerleading the defense case. I'm simply wanting to illustrate to you the legal merits of a possibly clever strategic defense. If you're enjoying the analysis in this episode, please like, share, leave a comment, and let's get started. So why would Kohberger want to go to trial? Why would he want a trial? Why drag it out? Well, because Bryan's primary locus is A, how smart he is, B, showing everyone how smart he is, and C, showing how smart he is about his area of expertise, his pet topic, criminology. And so what we are about to see, what is going to play out, is either a PhD taking names and beating the system at its own game by a criminal mastermind, by an evil genius, or someone who may fail spectacularly in the full glare of everyone watching. Which one do you think it's going to be? And that then brings us to reasonable doubt. Again, Bryan is a nervous fellow, but the one area he has confidence, perhaps even a reasonable confidence, perhaps a false confidence, is in his academic acumen. And one reason why he may have reason to believe in himself in that area is because some of his lecturers have had nothing but good things to say about him. And so his theoretical knowledge of criminology, who knows how far that's going to take him in this particular situation. To be fair, as far as I know, he's not actually a law student. He hasn't studied the law and he's now in a legal setting. He's not studying criminal law per se when he's studying criminology, as much as just one of the many processes within the justice system, which is, for example, part of criminology is evidence collection, profiling, protocols for DNA processing. If you look at the generic definition of criminology, it's the study of crime and criminal behavior. It's informed by principles of sociology and other non-legal fields, including psychology, economics, statistics, and anthropology. And funnily enough, those are all fields that I often touch on. Psychology, economics. I've got a degree in economics. Statistics is something I also studied. And we've gone through a lot of that anthropological stuff with Ernest Becker. Criminologists also study the characteristics of people who commit crime. So, that is criminal behavior and profiling to some extent. And so the question is, how much can that academic theoretical knowledge help in the real life setting of a courtroom where legal issues are being dealt with? How much is this knowledge going to potentially help Bryan? Now, who knows, perhaps that expertise may be the defense argument this case needs to gain an acquittal. It's entirely possible that the single DNA bingo on the knife sheath does have some questionable aspect to it. Maybe it's somewhat incomplete, the profile. Perhaps there is a possibility of contamination. Perhaps there is some sort of questionable conduct in the collection, sampling, or processing area. And just in my own coverage of this, I've seen people step on those surgical gloves, right? We've seen the CSIs go into the crime scene after the fact, not wearing any booties. So if they can raise doubt just around that, it could be job done. Just around that DNA profile, the evidence collection is questionable. Well, then the prosecution already have a serious problem on their hands. Also, if Bryan was typically a night owl in terms of his behavior, if he often went to Moscow at night anyway, right, if he went there to eat meals, does that really prove he went to 112 King Road? His phone pinging off a tower doesn't necessarily mean he was right there at that road. It means he was in the general neighborhood. And unless they have the license plate or a good view of the driver inside that white vehicle, can they really place him at the scene? They can place a white vehicle at the scene, but there are a lot of white vehicles, as people have found out trying to find the Elantra. So are there holes in the affidavit? Mark Garagos, the man who almost succeeded in his defense on Scott Peterson, has said the holes in the affidavit are so big you can drive a truck through them. He's right. The actions or lack of action by D alone, one of the survivors, that automatically creates reasonable doubt. She sees the killer, she even sees his eyebrows. She's able to provide a description of his clothing, his height, how he moved towards her, how he exited, also how she overheard the victims, someone saying something about helping someone, and even the dog, all of this at the time of the incident. And then she goes back to her room, closes the door, and goes back to sleep for almost 8 hours. Did she really see or hear anything if she wasn't compelled to report anything for so long? Or is she hiding something? Now, these are hardly defense arguments. These are natural questions that arise that we're all asking anyway. And let's face it, Koberger was never an obvious candidate for a suspect here. There's no obvious motive here either. We thought it was going to be someone close to the victim, someone who encountered them directly that night, either in the corner club or the grub truck or at a party, a frat party, or a party on some other occasion. But we thought we were dealing with someone much closer to these victims, someone connected to them, someone who had been inside that house, been to one of those parties, someone that could have been potentially dozens, even hundreds of kids. Are we really meant to believe this is that guy? Someone committed quadruple murder, someone who seemed to know the inside of the house intimately, but had actually never been inside the house. There's no proof that Bryan had ever been inside the house, even no clear indication that he had any connection, even met any of the victims. Are we really meant to believe that he's the guy? We believe we know how he exited the scene, but how did he get in? If he got in through the front door, how the heck was he able to do that if he'd never even been there before? Also, no blood trail. I'm just going through some of what the defense might highlight, and the prosecution needs to think about this. They need to have counter-arguments to this. They need to have strong, compelling counter-arguments to some pretty strong ammunition from the defense. And bear in mind, the jury is going to be watching. The jury is going to be listening. The jury is going to be thinking about this themselves. Which narrative is going to hold together better? Now, in terms of there being no blood trail, it looks like someone wiped up evidence. Someone cleaned up behind them. It looks like someone didn't commit a crime and just rush out of there. Otherwise, they would have left a blood trail through the house, out the door, and so on. And yet it seems like even the survivors didn't notice a blood trail. Otherwise, they would have called the authorities earlier, and they wouldn't have called to say someone was unconscious. They would have said, there's blood here, and it seems like someone is in, urgent danger. Didn't Dee notice that blood herself when she was standing there? If she noticed eyebrows, did she not notice a bloody trail coming from Xana's room? So, if we are dealing with someone who wiped up evidence, if you say that's the other side of the story, he wiped up evidence on the stairs and upstairs, the top floor, and was comfortable enough to stick around and go to the bathroom to do that, to clean up, well then, wasn't the criminal someone from inside the house? And there are other problems too. If the killer really committed the crime at 04:17, why do so not only when some of the victims were still obviously awake, right, with the lights on, with the phone on, with the door opening to the delivery of the DoorDash order, and you would imagine Xana taking that DoorDash order, the bag, to the kitchen. Well, the lights would have been on. You would have seen that activity. So why commit the crime on the heels of a DoorDash order? Was this really someone who came in from the outside, or was it someone already on the inside? Perhaps someone we don't know about, someone else who slept over, who was awakened and perhaps coming off a bad trip. The fraternity angle that the killer came from inside one of these fraternities, and some kind of pact of silence has protected him ever since. That was kind of a obvious theory that developed right in the beginning. Isn't that the most logical theory? And again, I'm certainly not here to plead the defense case. I'm here to prosecute this case. I'm on the state side. What I want you to see is that this is hardly a slam dunk. That there are certain cracks in the case, and if Garagos is right, holes. Koberger is either going to emerge from this as a respectable Dr. Henry Jekyll, or as a murderous criminal, Edward Hyde. Or who knows, perhaps both.
We'll see if you're as smart as we all hope you are.
Thank you for listening, and I'll see you guys next time.